Today in court, IEBC submits Forms 34As, 34Bs and 34Cs at the Supreme Court. Legal teams dig into the NASA petition as the preparations for courts continue. Clerks at the Supreme Court race against time to prepare a summary of the case as the pre-trial conference approaches. Now, good evening and welcome to the Supreme Petition, the first night of the program. My name is Joe Agail. Now, time is ticking away and the countdown is on for the Supreme Court to hear and deliver its verdict on the 2017 presidential election petition. Tonight and every night until that decision is pronounced, I'll be here with all the updates on that case. Also with me on the case is my colleague Sophia Wanuna, who is right now at the Supreme Court with the latest. Sophia, what is the update from the Supreme Court today? It's day 4, that's right?
Indeed, Joe Agayo, it is day 4 of that countdown that you mentioned. And today, a flurry of activity that was witnessed here at the Supreme Court. When was the team from the IEBC, that is the first respondent in this petition, led by the CEO, Ezra Chiloba, delivered 54,000 pages of documents. And these include Forms 34As, Forms 34B, as well as C. And we understand as well as the voters' register. So that was delivered here at the Supreme Court earlier on today. Remember, of course, the expiry of that service of the petition was Friday, which we saw NASA submit here at the registry of the Supreme Court. Then the 14-day timeline, which we're talking about, started on Saturday. So today being day 4, what happened within the first 2 days is that the petitioner, that is Raila Odinga, served the respondents, that is IEBC, the IEBC chair, as well as President-elect Uhuru Kenyatta. Now, they have 4 days to respond to those, to the petition, rather, that has been served to them. Today, they're on day 2, so preparations on the same, going through the petition. We saw 25,000 as well pages of the petition delivered here by the NASA team. So the respondents, those 3 respondents, have until Thursday, Joe, to file their submissions. Now, after that, if there are any other written submissions that may be needed, that the petitioner may want to make, they can do so on Friday, and that is by 1 p.m. And if the respondents have other submissions they'd want to make, they can do so on that same Friday by 7 p.m. So those are some of the critical and crucial timelines that we'll be seeing here on out, waiting for the respondents to file. And then if there are any other follow-ups, they will have Friday as a day to do that. But also important to note at this point, remember in the 2013 presidential petition, the Attorney General joined as an amicus curiae, which is a friend of the court, and sources indicate this time around he will also be joining this particular matter, and he has until Friday, that is 1 p.m, to be able to file, of course, to be part of this petition, as well as, of course, file his brief. That is what it is he intends to submit before the court. And after that, Joe, what we'll be seeing is a pre-trial conference where the parties will sit and really just hash out all of the areas and the matters that will be coming up before the judges at the Supreme Court. It's a 7-judge bench. However, we understand quorum is made up of 5 judges, so they don't all have to sit. We could only have just 5 of them sitting. Joe, also to mention tonight, a lot of speculation has been ongoing about who will be the counsel we'll be seeing, the various counsels we'll be seeing in the Supreme Court. Of course, we expect the best and the brightest in the legal field. What we can say from the NASA team, of course, the petitioner, that's Raila Odinga, the likes of James Sorengo definitely likely to be seen there. We have Paul Mwangi. Otiende Amolo as well is one of the names that has been fielded, Willis Otieno, as well as Ben Shihanya. But we'll wait to see who actually will be the counsel that will be addressing the court. On the IEBC, that is a first respondent, we understand there's Paul Mwita there, as well as PLO Lumumba. We also have a man, a lawyer, Senior Counsel Paul Nyamodi, as well as Karori, and that is Kimani Karori, who has been representing the IEBC even in the last petition. So those four, we understand, will be representing IEBC. For the president, Fred Ngatia is a name that we have heard, as well as Ahmed Nasser Abdullahi, but for that we'll have to wait for a confirmation. So Joe, for now, that is how it's looking in as far as the council, where we are with the timelines, and what to expect going forward. Joe.
Sophia, I have one last question for you. I think the big question on the minds of many Kenyans tonight is, when do we start hearing those arguments? When are those lawyers going to begin canvassing whatever positions they represent in this case?
All right, Joe, yes, that is the critical point at this particular juncture. Of course, a pre-trial conference will be getting direction from the judges after they sit and conference together with the parties. But what the chief registrar of the judiciary had indicated on the 8th day, then we should have the session in the Supreme Court kicking in. And of course, Kenyans being able to witness and hear various counsels submit in court.
All right, thank you very much, Sophia Wanuna, our reporter at the Supreme Court. She'll be keeping an eye on that monumental case that we will be following throughout this week and next week as we follow through the 14 days within which the court, the highest court in the land, must hear this case and make its pronouncements. And we're going to talk about this with a gentleman and a lady who know something about the Supreme Court and how cases could go in this country and previous ones. And I'm just going to introduce them in a moment. Here, I have Kakai Kissinger Francis. He's a Kenya human rights activist and attorney. He's a public interest litigation lawyer with a specialty in international human rights and constitutional law. He consults on electoral process, democracy and governance issues in Kenya and within East Africa. And he had some front row experience with the 2013 presidential petition, and we're going to be talking about that in a moment. Next to me is Waikwa Wanyoike, Executive Director, Katiba Institute. Thank you very much, Waikwa. He's an advocate of the High Court of Kenya, a barrister, solicitor with the Law Society of Upper Canada. Waikwa has advised government and non-governmental agencies on constitutional implementation and reforms. And in a short while, we'll also be joined on the panel here by Dr. Linda Musumba, who is the founding dean and now senior lecturer in the Department of Public Law at the Kenyatta University School of Law here in Nairobi. She holds a PhD from the University of Birmingham that she acquired in 2007, and she's going to be joining us here in a short while. But just to give us a sense of what perhaps we could expect or maybe not, why don't we have a look at what happened in 2013 and what that case really was about? And that's with Asha Mwelu.
What most Kenyans don't remember concerning the dispute surrounding the presidential election in 2013 is that a total of 3 petitions were actually filed at the Supreme Court following the announcement of Uhuru Kenyatta's win by the IEBC in March 2013.
In full realization of the high calling,
I assume as President of the Republic of Kenya.
I assume as President of the Republic of Kenya.
The first petitioners were Dennis Itumbi, Moses Kuria, and Florence Sergon, who sought the court's determination on whether rejected votes should be included when determining the total number of votes cast. The second petition by AFRICOG, represented by lawyer Kathy Kilonzo, sought to invalidate the presidential election on different alleged irregularities in the registration of voters, the electronic voter identification, and vote tallying. The third petitioner was Raila Odinga. He was represented by lawyer George Oraro. Raila wanted the presidential results invalidated, alleging that massive electoral fraud and malpractices aided Uhuru Kenyatta to win. So while the Supreme Court had 3 separate petitions on the 2013 presidential election, this time there is only 1 petition filed.
All right, so welcome back to our panel here. And as I promised, Linda is now with us, Dr. Linda Musumba from Kenyatta University. now senior lecturer there. Thank you very much for joining us tonight. And I'm sure you've caught your breath a little bit, and we can
Yes, I have. Thank you.
Yes, we can just start with you. We did have a petition in 2013, and we'll talk about it in a few moments. But what is this current petition really about?
Thank you for that question, Joe. And for me, I think that when you look at the current petition, it mirrors a lot the 2013 petition. The issues seem to me to be fairly the same. It is still a question of whether the votes allocated to either party in that contest can be defended. And therefore, this is still, to me, an issue of being able to verify the accuracy of the vote count.
But that is bound to be a technical thing. I mean, I remember in 2013, there was the whole conversation about servers and IP addresses and that sort of thing. I mean, to what extent does that make it difficult for many of us out here to follow a case like that when people are going to be talking about the cloud and servers and all manner of things that are very technological in nature?
For sure, of course, there's been a step up in these particular elections with respect to the level of technology that has been used. And therefore, you know, the constant reference to the use of ICT, the constant reference to the use of, you know, computing systems and technologies to be able to verify the accuracy of the vote count. This, of course, is a step up from 2013. This time round, the levels of testing were being able to see your face, being able to identify you on KIMS, and then also being able to check your biometrics. So the levels for checking the accuracy of, you know, the vote count have been increased in these elections.
Okay, Kakai, I mean, you were, as I mentioned in the front row, you were still at the judiciary at the time and saw these things a little bit more up close. This whole idea of technology in a case of this magnitude, and considering that the reason why the case is even in public is that so that the public can actually follow every step, because that helps in the end with whatever verdict comes up, people feel like they have followed it through. But how easy is that when there's so much about technology, some of the complicated stuff that not very many normal, ordinary Kenyans walking on the streets out there might actually follow?
Thanks. When you look at the petition, if you read the petition, and you look at the grounds or the issues that they are raising, and you compare it with the previous petition, the 2013 petition, you can see a mirror in terms of issues. Now, the 2017 petition, they are having about 11 issues that they want, questions rather, that they want the court to answer. But these 11 issues or questions are before the pre-trial conference. And once we have the pre-trial conference, they will narrow down onto issues. Now, one of the key things in their petition, which now is leaning towards technology, which was even there in the 2013 petition, only that it changed, the technology failed in the 2013 petition, and then they relied on manual vote count. Now, this time around, the petition is premised on the fact that, fine, the technology was there, but there was a problem in terms of transmission. So the key issue for them to prove, which is now unique with the previous petition, is the transmission that occurred from the polling station, constituency tallying centers, and to the national tallying centers. And the processes that were supposed to follow that transmission. And in the arguments, they are saying that the law required IEBC to transmit the results with a photo of the Form 34B. And that is the biggest challenge. Now, in terms of proving this, I have not had a chance to look at the affidavit, because now looking at the affidavit are issues of evidence which will be debated in court. But I can imagine they will have to look for an IT expert to come and actually assist in terms of understanding exactly how technology was meant to work.
Waikwa, you have followed this case, this current one, the last one, and so on, and we're looking at this whole thing of technology, and my question to you is, does this make this case more difficult to deal with? I mean, lawyers are not necessarily IT experts, and therefore, as Kakai says, you will still have to bring other people who bring in technical expertise. How different is this from typical presidential election petitions?
Thank you, Joe. I think technology is obviously an important feature in this petition, and especially the issue of transmission and whether there was any interference during transmission, whether there were problems with the server, and all that. But while we think about how the case itself will be prosecuted or how it will be tried, we have to think first about how much time the court has and what kind of evidence it's willing to accept, or the form of evidence. It would have been preferable if there was enough time that experts be called to explain what the differences or what the concerns are about technology, while you call the experts on the other side.
It's interesting you raised that, because we understood the other time when NASA was filing the petition on Friday night, one of the things we were told by Councillor Orengo was that the whole thing was actually 25,000 pages. Today, Sophia was telling us how the IEBC filed some 54,000 pages of whatever it is. They were filing 34 A's, B's, and C's, and whatever. And here we are, within the next 10 days or so, all these other preliminary processes would have happened, and then the judges have sat, the lawyers have basically argued the cases and so on, and a verdict given. What would the judges be looking for? I mean, like, those are thousands and thousands of pages. I don't imagine that anyone would be going through all of them. How does the bench cut through all of that and still come up with something that can be seen to be fair?
My view is we only have about 6 days when judges will hear this and make a decision within those 6 days. And my view is it's very unlikely that they will be calling witnesses to come and explain some of this aspect. So a lot of this might hinge on what the parties themselves have filed in form of affidavits and other evidence. And then the ability of the advocates to point to the court specific concerns they have, and then hear the responses from the other side, and then the court makes a judgment which side they want to believe. That is likely going to be the way they determine it, because in a usual case, what the judges would have done is to call experts, or to ask that experts come and explain these things in more detailed fashion.
And I'll be talking about how, whether that is really such a big problem or not, because it emerged after the 2013 when court, then the 900-page affidavit was rejected on those technical grounds, and we'll be talking about that. But Dr. Musumba, we are here talking about all these many pages, and yet at the end of the day, there has to be a verdict. At the end of the day, every lawyer will be going out there to put their best foot forward. If you're in the shoes of the lawyers who are prosecuting NASA's case, what is that you're trying to do as that lawyer, that team of lawyers who are trying to convince the judges in only 6 days in light of all of these things? What can they possibly do?
Joe, obviously, being inundated with a huge corpus of documents to look at is a challenge, of course, for the judges to be able to, go through all these documents during this very short time, as well as, each of the opposing teams to be able to look at the documents that there are. However, being able to highlight your client's, best points, the best of your ability, is a fusion between the pleadings that you've done. If you've extended them and made them extremely voluminous and therefore impossible for any judge or anybody looking at it to be able to get to the point you would like them to, then this must be made up for in the oral arguments that are made by counsel. Therefore, your strategy must, of course, take into account that fusion, that the oral arguments that are highlighted in court have got to be on point. Whoever is making these arguments for both sides has got to be able to pinpoint what are the issues that will actually, on which the case will turn. So that when judges are listening to this, and even as they go back and refer during their spare time, on the issues that have been raised, they need to remember your voice as an advocate, being able to pinpoint those things on which the case ought to turn. So for me, I would look at it as
But from a cursory look, I mean, obviously, we will have to deal with evidence as it's placed before the judges and all that. But from where you stand, what are those things that stand out in this case that, as you mentioned, the case might turn on? Like, what are these things that NASA, for instance, will have to prove to the court or demonstrate very, very incontrovertibly for their case to stand a chance?
Naturally, of course, the most fundamental basis for the presidential election petition and all other petitions is the allegation being made by the person contesting that you are announced the winner, but I don't think you are. And therefore, the reasons you advance to support your allegation that this individual won and they did not has got to be such that it displaces, in the mind of the court, as well as in accordance with the law, the requirements for that election. And of course, the Constitution in Article 86 lays down the requirements for an election. It's got to be accurate, verifiable, it's got to be transparent, there's got to be accountability. There's all these things that have been laid out in the Constitution. Therefore, as a person who's alleging that your opponent did not win, you're saying, therefore, that the votes that were allocated to this individual were not merited. And so you have to be able to show through evidence. For instance, one would expect that if NASA had agents in the polling stations all around the country, if they did, that these agents would then bring the evidence that they witnessed or that actually is able to prove the fact that the forms as they were filled or the information that was filled there is not true. Mm-hmm. They may be able to bring evidence in other forms, and of course, this is something that will be seen as the days go by. For example, my colleagues here have mentioned that they could bring experts who could be able to provide further information on the ICT components of this election, which prove that, for example, when the IEBC says that they did do their job in accordance with the law, that this could not have happened. The allegations that there was hacking into the system or that there was an algorithm in the system that kept on multiplying numbers will be displaced by expert witnesses. So whatever the NASA will do, it has to be able to prove that indeed the votes allocated to our current president are not merited.
Wow, okay. Kakai, the whole question of the amount of evidence, or what every team would call evidence, and vis-a-vis the amount of time allocated by the Constitution for the hearing of this whole thing, is a debate that happened post-2013, and we are likely to run into it again, because at the end of this, someone might leave feeling that the court didn't quite go to the meat of some of the things that they presented. Where is that balance? Because I imagine there's a constitutional rationale why this thing has to be had within a certain period of time, but then there is also the other side where people are saying, well, that time also has to be reasonable enough for all the evidence that might be available to be dealt with. So where do we stand with that, even as we approach this case?
I think that's a very valid question, and let me take you through some constitutions, because sometimes when such kind of article or sections finds itself in our constitution, there's a basis to it. Now, I've been privileged to read constitutions around Africa, and when you look at South Africa, for example, just to try and elaborate and put this thing into perspective, why Kenyans settled on the 14th day, there's a reason behind it. When you look at South African constitution, it only allows election petition to be dealt with within 7 days, and that's it. When you come to Tanzanian constitution, it's very clear in the constitution. It says, if IEBC, if Electoral Commission of Tanzania has announced the result, presidential result, there is no appeal to that. That's the constitution. Now, when you come to Uganda constitution allows electoral petitions to take place, but to be decided within 30 days. When you come to Zambia, Zambian constitution is very interesting. The Zambian constitution says that once the results are announced, it should be, the president should be sworn in within 24 hours. It means, irrespective of whether there will be a petition or not, the president will be sworn in. However, petition can be filed and it will be dealt or dealt with within 14 days. Means that you can now imagine the difficulty once the president has been sworn in and removed. When you come to Nigeria, Nigeria is very interesting. Nigeria allows electoral petition after 108 days. I think that's like almost 3 months? 3 months to be dealt with. But the election in Nigeria will still, the president-elect will still be sworn in. You remember the debacle that took in Nigeria in 2003 when Obasanjo was sworn in respect to the fact that he did not win. Now, why do we have different regions, different jurisdictions giving different dates in terms of election petition solving? Because constitutions all over the world and laws all over the world and judiciaries all over the world are extremely reluctant to get involved in election petition. And the reason why they are reluctant is that they are saying that is the will of the people. So can you just please sort out your issues in the ballot and don't come to us? That's the jurisprudence behind it. So in Kenya, we adopted 14 days in terms of solving the dispute. I suspect that we thought, just like Dr. Linda said, somebody should come to court with a very top-on case, very critical evidence, one case only, and one evidence.
So you contend that
you
14 days is not too short?
It's not too short. It's sufficient. It's sufficient. Compared to the analogy I've given, it's very sufficient.
But weren't there some judges actually in post-2013 who were saying that perhaps if the 900-page affidavit had been admitted, then probably something different may have come out of that case, that was a case where a technicality was used to probably defeat what some lawyers have called substantive justice. The thing is, what Dr. Linda said, I really agree with what she said. Can I, for example, I've looked at, I'm not prosecuting NASA's case either, but I've looked at the issues that NASA has raised. Before the pre-trial conference, they have about 11 issues that they want the court to answer those issues. Why not just pick one issue? And when you look at these issues, they are all similar to the 2013. They had a very good analogy in terms of saying hacking took place. Now, when you look at the cases that have been decided in Africa, and when you look at the cases that have been decided in Europe, in Africa there has been no country that has invalidated a petition, apart from Cote d'Ivoire, which tried to invalidate the petition, but it didn't affect the end results. When you look at the countries that have invalidated a petition, it's only Ukraine and Austria. And they did that because the lawyers were able to prove that there was fraud. Fraud was involved. So NASA will have just gone to court with only one issue, the issue of hacking. But when you look at the petition that has been filed, hacking is not there. But Waikwa, maybe I throw this to you. I hear a lot of lawyers say that sometimes when you have only one, if it's dismissed, that's it. I mean, you kind of throw a big net out there hoping that something will be caught in the net. Isn't that a legitimate sort of legal strategy?
It could be, but I would disagree a bit with Mr. Kakai on this. I think, yes, NASA may have framed quite a number of issues. Maybe it would have been prudent for them to frame less issues. But if I was prosecuting this case, I would not frame one issue because it all depends also with the kind of complaint and your chances of success. Remember, NASA could fail on, if they have 9 issues framed, they could fail on 8, but succeed on 9, and maybe the 9th is the one that actually gives them the remedy they want, which is a fresh election. So for me, I can see the reason why NASA may want to frame those issues as long as they are separate. Remember, and I think this is critical, while the case that NASA has presented, or the issues that they framed, may look similar to the issues in 2013, I think this time round, what might change is the strategy. In 2013, if people remember correctly, I think the strategy then was to ensure that 50+1 was not met. This time round, that may not be the strategy, even though that is one of the issues framed. It may not be their primary strategy. When I look at their documents, their main concern actually is not even technology per se. It's actually whether this election was conducted in accordance with the constitutional principle, which what they are trying to do is to say the Constitution is supreme, and has there been sufficient violation where the court can say, look, you cannot fail to comply with the Constitution and expect us to validate the election. And I think that will be a major issue. Remember, NASA has also framed issues that were decided in 2013. So they are actually disputing some of the findings from 2013. I'll give you an example. They've framed an issue about rejected votes and whether they should count. And in 2013, that was a case brought by Moses Kuria and Itumbi. And in that, on that issue, the court said rejected votes don't count. NASA is saying we want that revisited. In fact, if you look at some of the issues they've framed, they're saying they want quite a number of issues revisited. So while people may think that it's the same issues, I think we'll see a totally different approach when it comes to the hearing.
All right. Thank you very much. We're going to take a break shortly, but Dr. Musumba, how much room does the Supreme Court have to go back on its verdicts in the past? For example, he's saying, well, they ruled on the rejected votes and it is back. What does precedent look like?
We have had, of course, the Supreme Court indicate that there is the indication that it cannot review its decisions. However, it did provide exceptions for when it can review its decisions, including, some of them include if parties, let's say, were not honest or truthful at the beginning. And there are two other factors. So it will be interesting to see the route the Supreme Court takes this time round, whether it will entertain something that it has ruled on before, this time round to be able to overturn it. So that's something that we'll wait and see.
But I can add on to that. Generally speaking, in legal jurisprudence, courts are very reluctant to review what they've already churned out. Now, in the Kenyan case, it even gets more complicated because the Supreme Court has changed.
Yes, exactly. That's the point I was going to raise. It's not exactly the same one.
The Supreme Court has changed. That time, in 2013, we had 6 judges listening to the petition. That time we didn't have a deputy chief justice. So then the bench said, okay, we'll hear all of us. Of course, the law allows them to sit 5. But 2 have since, actually 3 have since left. So I don't understand which magic the NASA lawyers will use to convince the new judges to unwrite what the former judges have already done. So that running away with the idea of the issue, revisiting the issue of ballot papers not counting as spoiled ballot papers as rejected might not run with them at all. So I just don't see any room.
But on that point, you see, as much as it's very difficult anywhere to convince judges to revisit and change their previous decision or court's previous decision. The one advantage we have, first of all, in the Constitution, there is a specific provision that allows the Supreme Court, not any other court, but the Supreme Court, to revisit and vary its decisions, not decisions, but its jurisprudence from the past. We also know, after 2013 presidential decision or judgment, there has been a lot of criticism of certain aspects of that judgment, which, in my view, some of those criticisms are actually valid. So then there is a question, has the court had the time, especially given the rush that was there to arrive at that decision, which is legitimate. And
the exceptions, I think I don't know whether it's you or Dr. Musumba, they seem to have been quoting, is it Article 167?
It's 163.7,
yes,
which is the one that allows them to revisit. Yeah. But more importantly, given what scholars have written about, given what reflections the Supreme Court judges have had, have they probably
but anyway, the discretion is still there.
Yes.
So anyway, we are going to take a short break, and when we come back, we can go more into this. And also that very interesting ruling that came in the run-up to the election from the Court of Appeal about votes being tallied at the constituency and being announced there. Is that going to feed into this discussion after the break?